Good afternoon. My name is Ronaldo Hilton. I'm the chair designee for the New York City Loft Board. Welcome to our September 15th, 2016 public meeting. I hope everyone had a wonderful summer. I'm looking forward to a productive time together with the board. Before we begin the formalities of our board meeting, I would like to introduce a new member of the board, and that is Supervisor Inspector Richard Roach from the New York City Fire Department, representing the Fire Commissioner. It's a pleasure to have you with us, Mr. Roach. We first turn our attention to a vote on the June 16, 2016 minutes. Are there any corrections or comments on the minutes? So,
yes. Will we adopt the minutes for the June meeting?
Sure. Are you moving to adopt?
Yes.
Okay, Mr. Delay is moving. Thank you very much, Mr. Delay. Is there a second? Mr. Bowers is, thank you, Mr. Bowers. Mr. Rivera, could you please pull the board?
Mr. Carver.
Yes.
Mr. Bowers.
Yes.
Mr. Rocha.
Yes.
Chairperson Hilton.
Yes. Abstain.
Mr. Delane.
Yes.
Ms. Golden Rivera.
Abstain.
Mr. Shafter. Ms. Sheldon.
Yes.
5 in favor, 2 abstain, and 1 absent.
Thank you, Mr. McKee. I'm also delighted and proud to introduce the Loft Board's new executive director, Helene Balsam, who took charge of the board beginning August 29th. Before I tell you a bit about Helene, whom I have known for a very long time, I'd like to take a moment to say thank you to Ms. Martha Cruz, our Deputy General Counsel, who functioned as interim executive director while we conducted a search for a new executive director. She did a wonderful job, and the staff of the Loft Board all stepped up and performed at a high level under her supervision. Helene began her legal career with New York City as a full-time staff attorney working at the Environmental Control Board in Brooklyn. Shortly thereafter, she was promoted to managing attorney. In that capacity, she heard and decided thousands of complex cases, including notices of violation issued under the building and fire code and zoning resolutions. She also supervised the work of up to 40 hearing officers. When ECD, which is the Environmental Control Board, was transferred to Oath, she became ECD's legal director and then Oath's Deputy General Counsel. Over the years, Helene has developed and delivered CLE accredited training classes for hearing officers on such topics as managing a hearing, ethics, and assessing credibility. She's a permanent faculty member of Post Administrative Judicial Institute. In the private sector, she has taught for Capital Education Services and has held adjunct faculty positions at CUNY and New York Law School. Currently, she teaches a class in law and legal writing at Benjamin Cardozo School of Law. Helene received a bachelor's degree from Brooklyn College and her JD from Boston University. And Executive Director also will now give her report.
Thank you. So I don't have that much to say because I've only been here a few weeks, but I do want to thank you all in advance for helping me make this transition, and I will be relying on your expertise as we go forward. My goals in terms of what I see us doing would be to try and streamline processes as soon as I learn fully what they are. And I definitely want to try and get whatever stalled buildings are there, and we all know that they're there, trying to get those buildings moving through the process, to get them legalized, and I will be working on redrafting the rules. I'm sure you'll all be happy to hear that. Next year we're going to start redrafting the rules. Let's try and make them simple, more straightforward. It's a complex law, there's not that much you can do, but I think from an organizational standpoint, there's a lot that we can do in terms of making the rules more accessible to everybody. In terms of my report, we are ending the registration cycle. At the moment, I'm happy to report we have 277 buildings fully registered. There are 55 buildings that still have not registered. Out of those 55, 5 we are just waiting for a payment on late fees because their payment of time, and then we have one building that paid but did not file the registration application. So that's it for today.
Thank you, Ms. Walson. I just want to let you know that we have complete confidence in Ms. Walson's ability to move things along. I have extensive work relations with her, and I know she will do a good job here. And we look forward to working closely with the board members to make this the mission of the Loft Board, to move forward the mission of the Loft Board. We next turn next to the summer calendar. There are 17 summer cases. These cases are voted on as a group. They are KNC 2 LLC at 235 to 241 Barry Street in Brooklyn, 216 East 95th Street LLC. Address is 43. I'm sorry, at the left of the docket number for the first case is LS 0223. The second case is 216 East 95th Street, 95th Realty LLC, 43 West 27th Street, docket number LS-0235. And the third case is Claudia Diaz at 19-27 J Street in Brooklyn. The docket number is PO-0023. Fourth case is Michael Sealer at 151 Kent Avenue, Brooklyn, PO-0027. We have the fifth case involved various tenants of 169 Spencer Street. And that, of course, is 169 Spencer Street, Brooklyn. Docket number TH-0204. Then we have Kate Burkhart, Dale Mary, Vanessa Regal, Bill Abbott, and Chris Barber at 47-53 South 5th Street, Brooklyn, TM-0080. The seventh case involves various tenants at 169 Spencer Street again, 169 Spencer Street, Brooklyn, TM-0085. The eighth case involves Raphael Palin May at 255 McKibben Street in Brooklyn, TR-1162. Then we have the ninth case, Barry Mann et al. Address is 65-75 Roebling Street in Brooklyn, TR-1198. 10th case involves Brian Hubbard et al. At 65-75 Roman Street, Brooklyn, TR-1199. 12th case involved Alexander Berklick and Nathaniel Banfield at 65-75 Roman Street, Brooklyn, TR-1204. 12th case, Daniel Arch et al. 49 Wyckoff Avenue, Brooklyn, TR-1219. 13th case involved Nicholas Bennett and Mark Lozinger, 151 Kent Avenue, Brooklyn, TR-1227. 14th case, Kimberly Mann, 65-75 Roman Street, Brooklyn, TR-1229. 15th case, Raphael Taylor at 440 Broadway. That's Manhattan.
Yes.
Manhattan. TR-1275. The 16th case involves Cedric Wilson, 101-105 Water Street in Staten Island, TR-1281. And finally, we have Sai-Hong Zhao at 816 Broadway, Manhattan, TR-1292. Does anyone have any questions or comments about these cases? Mr. Lane.
I just have questions on a couple of cases. The first of which is number 8 on the docket. This concerns, apparently, as I understand it, a building where 5 units had their coverage withdrawn pursuant to administrative determination. The owner had registered them, and it was determined that all 5 of the units were in the basement of the building. Now, it's possible to legalize an a unit in a basement, but the 2010 amendment to the loft law that added section 281.5 created an exception that said that no unit can be in a basement. So the question that I have is, this case seems to involve one of those 5 units, but have we made any determination as to the status of those 5 units, or the other remaining 4 units? Are they still being residentially occupied? Have we inspected?
We have not inspected. No, we have not inspected. They were deregistered, and we have not inspected. The Loft board has not inspected.
Warren, the new chairperson, the new executive director, and sometimes I'm a third grader, the person who I'm strangling in 3rd grade for asking too many questions, but the concern with the exclusions in the 2010 expansion of the Loft law is that there are units that we believe should be brought into compliance as affordable housing rather than excluded from coverage, particularly in a case such as this, where the language that was inserted into the law in 2010 said that units in basements and cellars cannot be legalized. There's no reason cellars, you can't legalize a dwelling in the cellar in any kind of way.
Is this involved in a cellar or a basement?
These were determined by the former executive director to be, as I read her administrative determination, to be basement units. I would also note that I would occasionally make requests to be provided with a copy of administrative determinations. That did not happen in this case. So the first I learned of this was when I received these cases last Friday, whereas in fact this determination was made in 2012. I think the law, which is the law, state law, I don't think the state law that excludes basement units from coverage under the Loft law is correct, but it is the law, and with all these exclusionary provisions, the concern we have is it's either a covered unit or it shouldn't be residential. And the fear is that a lot of these units and a lot of these buildings that will be excluded from coverage, whereas in fact they could have been brought into compliance, will continue to be used residentially at higher and higher rents and without proper public oversight.
So is your point that they should be inspected to make sure that they're not?
At a minimum, yes, they should be inspected.
Okay, so.
I mean, it's my understanding that there are plenty of Class A apartments in the city that, I don't know what quite the difference is between a basement and a cellar.
It has to do with how much is above ground and how much is
Well,
below
it's,
ground.
yeah, but if there are windows,
There's a definition there. Windows do play a part in it, but it has to do with the height of the percentage of the livable space that is below the
below
grade. Below grade.
Now, depending upon the grade, just one moment. If you count the sidewalk grade, but maybe in some buildings, there's another grade in the backyard that's beneath the sidewalk grade. Now, would that then be covered by the sidewalk grade, or would it be covered by the grade outside the
I don't believe
building?
there's a technicality there. I'm not going to, speak so authoritatively, but maybe.
Pretty sure it's the street.
Street
It's
grade?
not the back, yeah.
We'll make that clear, but I'm not sure if, I don't want to say. But your point, you wanted a clarification on that?
No, I would like a clarification on it, because all I'm saying is that there are some Class A apartments that have been in existence for years and years and years that do not conform, and yet people are living there. And maybe what we ought to try to do is to amend the rule a bit. The whole point here is, I understand that the lofts have to be sort of livable, and, but this whole business with light light and air had changed dramatically with the new Loft. Right? We certified a building that had 2 transom windows. That was it. A transom window into a vestibule, and a transom window from the vestibule into the living dwelling itself. And that was legal. Now previously, there had to be a window directly out from a bedroom. And somehow we sloughed over that. And the idea of 2 transom windows legal, I mean, it's just sort of nuts to me. So I think we ought to kind of look into this thing because, you know, housing in this city is extraordinarily dear. That's my opinion.
All right, we'll definitely clarify for you and send an email to the board. Now, I just wanted to say something though. When the legalization process is handled by the registered design professionals, reviewing plans and applying all sort of different laws, code laws and zoning resolutions and stuff, and there's alternatives, as the architects will tell you, and engineers will tell you that there are alternatives, so, you know, that can be applied, such as ventilation can be done mechanically, and lighting can be, can also be done artificially. So we don't know. I mean, I'm not an expert, but we'll clarify for you and get back to you. Are there any more comments?
Mr. Chairman, I'd just like to point out that this particular case is one that the FDNY has made notation of, that we'd like to go on record as stating that we believe we should go in there and inspect to ensure the safety of the tenants that reside at this McKibben Street address.
Sorry. One second. Okay, so no, thank you.
And again, just to wrap this up, we've also run into cases where the street is on grade, so that a portion of the unit may be street level, and a portion of the unit will be maybe on the basement level. Obviously, the position of the tenant population is that we would like to see amendments to the state law, which is beyond, outside the board's authority, obviously, to take an approach that would permit building units that can be made compliant to come into compliance for exactly the reason that if they remain out of compliance, that sets up a situation where either they're going to be inhabited when they shouldn't be, or the owner may be in a position to say, well, you know what, I'll let you stay here, but it's really not legal, so why don't we double the rent and I'll let you stay. So if you have a vulnerable unit, it should either be made legal or it shouldn't be in this kind of limbo world.
Thank you, Mr. Day. Are there any other comments on these cases?
I have 2 more cases.
Yes, sir.
This one is for Martha Cruz.
What number?
Number 12, 49 Wyckoff Street. This is a building that has never been registered. It doesn't have an IMD number. And pursuant to a stipulation on March 30th of this year, the tenants withdrew their coverage claims with prejudice. The stipulation, they require them to vacate the premises. So that's not an issue here. But the stipulation also said that the landlord was buying out their rights under section 286.12 of the Loft Law. The problem is, if it's not an IMD, if it's never been registered as an IMD, the owner should not be in position, the owner can't buy the rights to a unit under the Loft Law if the unit isn't and has never been covered by the Loft Law. So my question is, would you interpret that at a future date and time as being a 286.12 sale where this building would come back before us?
Well, it wouldn't be that I interpret it. The issue, if the building were to register, the owner were to register the building and file with building was subject of a sale prior to the registration. The staff would accept the filing, but ultimately the decision would be the board's decision when the issue comes up in the removal case, whether to accept that filing as a buyout under 286 Section 12. I mean, the board can, at the time that the building is being removed, if the staff were to even accept the filing, it would come before the board that that this filing was made the staff, and that and the board at that point could reject the recommendation by the staff if this recommendation was that it should be interpreted as a 26, 6, and 12, and because rejected.
Okay. I would just note that I disagree with that, and rather than take more time with the meeting, I'll file an opinion explaining my concern. You may have noticed there was another case on this agenda where a tenant filed for coverage just a few weeks after the owner had, the new owner, or no, I think the current owner had filed a 286-12 purchasing rights from a prior tenant. The problem in that case was that the purchase of rights had taken place 3 or 4 years before. And there's been a persistent problem where owners get the 286-12 sales agreement from the prior tenant, which exempts the unit from coverage. But the owner never files it with the loft board. Somebody else moves in, thinks they're protected under the loft law, goes to the expense of filing for coverage, and only then, like the get out of jail free card in Monopoly, does the owner cough up the 286-12 sale. And we haven't found a mechanism to say, if you buy rights, file the paper right away so that people can do due diligence. And in this case, I don't think you can buy rights from a unit that's not covered in an agreement that says this is a purchase of rights under the law when the law was not in effect at that time. And last, we have number 16. Here we have case 10105 Water Street, Staten Island, where a tenant filed for coverage for 3 units on 1 floor, and has then withdrawn the application without prejudice. And my question is, do we have a mechanism in place for tracking this kind of building? That is to say, buildings where somebody comes in, makes an allegation that A, the building is being residentially used, and B, it appears to qualify for the loft law, and then withdraw.
We have the building and the application registered in our system. That's the extent of the tracking.
Okay. All right, that's all.
I just want, can you clarify your point there? What's the tracking you're thinking of?
In this case, looking at the record, there's very little. The tenant involved was represented by Staten Island Legal Services. The application was filed. The attorney withdrew it. There's no hint as to what the reason was. The concern I have is a variant of and this is an issue that's come up, and I'm sure Martha can fill you in at some other time if you haven't discussed it already, but there are buildings, and we have a few lawsuits related to this, where at some point in time, after filing for coverage, the landlord and tenants determined that they could perhaps strike some kind of deal to continue occupancy outside the view of the loft board. And some of these have been very elaborate. You know, the owner promises to bring the building up to code under a certain timetable, and it just obviously, as although I represent tenants, I also have an interest for the general public. If these buildings, if there are multiple dwellings that are being used residentially, they ought to be under some form of overview and regulation. So hopefully there's some way to track that.
Just so, I should also mention that for this particular building, we did make calls and confirm that the person no longer resides there.
That particular unit.
That particular individual, yes.
But whether or not,
The other.
if indeed there are 3 units, and if indeed they're being used residentially, that we didn't determine.
Yeah.
Thank you, Mr. Delaney. Are there any other questions about these cases? With that, is there a motion to accept the summary cases? Mr. Carver, seconded by Ms. Shelton. Thank you very much. Mr. Rivera, would you please report the order?
Mr. Cocker?
Yes.
Mr. Myers?
Yes.
Mr. Dozier?
Yes.
Chairperson Newton?
Yes.
Mr. Delaney?
Yes.
Ms. Golden Rivera?
Yes.
Ms. Shelton?
Yes.
7 in favor, 1 absent.
Thank you, Mr. Rivera. We now move to the master case calendar. We have 2 coverage cases. First coverage case involves an applicant, Jen Gatien, applicants Jen Gatien, David Mullen, George Dewey, and Kelly Kirk at 43-49 Beaker Street. Docket numbers are TR 1060, TR 1111, and TR 1163. Ms. Cruz, will you please present these papers?
The applicants of units 306, 406, and 503 and 43-49 Beaver Street filed applications seeking Article 17 coverage pursuant to MDL 2815. The owner of the building opposed the applications. In the report, Judge Globe recommended the board grant coverage to units 306, 406, and 503 and grant tenant protected occupant status. Judge Globe also recommended findings for units 407, 501, 502, and a unit called the Stone Unit. Staff recommends that the board accept Judge Globe's recommendation regarding units 406, 406, and 503. However, reject her recommendations regarding units 407, 501, 502, and the Stone Unit. Tenants do not seek coverage of units 407, 501, 502, and the Stone Unit. Reliance on these findings was not necessary to reach a decision on the applications. In his opposition to the coverage of the building, the owner admits that the building does not have a residential certificate of occupancy, but argues that it's exempt from the requirements of MDL Section 301. It argues that the residential occupancy is legal because at the time that the building was built, it was not required to obtain a certificate of occupancy pursuant to Section 301. Section 301 of the MDL has 2 exceptions. One of them is an old loft tenement erected after April 12, 1901, and occupied for 2 years immediately before January 1st of 1909. HPD's records admitted into evidence do not indicate when the building was built or whether there was any occupancy in 1907 or 1908. Judge Glow found that the owner failed to offer evidence that would prove that the building is exempt from the certificate of occupancy requirement. The staff recommends that the board accept Judge Glow's finding. Regarding the unit seeking coverage, owner stipulated that Unit 503 meets the eligibility criteria of MDL 2815. For Units 306 and 406, the owner disputed that the units were eligible for coverage. Judge Glow found that Unit 306 and 406 had windows that face the street or lawful yard or court, were more than 400 square feet, and were not in a basement or cellar. The staff recommends that the board accept these findings. The remaining issue is whether these units were residentially occupied for 12 months during the window period. Mr. Encisa, a former occupant of Unit 306, testified that between 2003 and 2009, he used the unit for residential purposes. In addition to his testimony, Mr. Encisa also provided documentary evidence in support. Judge Glow found that Mr. Encisa credible and found that the unit was eligible for coverage. Regarding Unit 406, Judge Glow found that George Dewey and Kelly Kirk provided credible testimony and evidence establishing that they residentially occupied the unit during the window period. Judge Glow found that Unit 406 met all the eligibility criteria for coverage. The staff recommends that the board accept Judge Glow's credibility assessments and find that the building is an IMD with 3 units, units 306, 406, and 503. Protected occupancy determinations are governed by Section 209 of the Loft rules. The record shows that the tenants have not permanently seized of their respective units and that they residentially occupied their units on June 21st of 2010. As evidence that she moved in prior to June 21st of 2010, Ms. Gation submitted copies of canceled checks dated May 2010 and June 2nd of 2010. Mr. Dewey and Ms. Bird testified that they took possession of their unit in August of 2007. The owner did not dispute their testimony. Regarding Mr. Mullen, although he did not explicitly raise a protected occupant claim in his application, he did raise it during the course of the trial. The claim was properly before the board. He testified that he moved in 2005. The owner's witness, Mr. Manny, the owner's building superintendent, provided testimony in support of Mr. Mullen's claim. Finally, staff recommends that the board grant Article 7C coverage to units 306, 406, and 503, pursuant to MDL 2815, and protected occupant status to the tenants.
Thank you, Mr. Do we have any questions or comments about this case? I recognize Mr. Brooklyn.
In reviewing this particular case, it should be noted that Unit 306 in the package that was provided to the FDNY, it clearly states in several locations that Unit 306 has a constructed wooden structure within the unit with stairs leading up to the bed. In research that was done by my office, we determined that this is a sprinklered building. The building is sprinklered, and as such, there could be a concern that this loft structure that apparently was added by this tenant, Mr. Stolman, could obstruct the sprinkler flow of water to the area beneath. Additionally, the loft space clearly states in the legal document that it's being used for sleeping quarters. So the FDNY would like to go on record as saying that this is a location that we have no objection converting to an IMD, but we would like to inspect Unit 306 for the safety of the tenants.
I'm curious, was there any photos?
I believe so, but I don't remember seeing any evidence.
I think we had some floor plans, Mr. Chairman. Pretty sure this was the one that they had submitted some floor plans with. I do not recall any actual camera photographs.
There were some photographs, but I don't believe it was in the mezzanine area. The area photograph shows.
Okay, duly noted, Mr. Roche. We'll speak. And see if we can get that done.
So, let me ask.
I'm sorry, Mr. Daniels. You want to follow through? Is it all right? Sure, go ahead. Mr. Barnes.
So if the FDNY finds that this lost sleeping space is hinders the unit, what would you do? Would you have that removed?
Well, we would have to take appropriate action in accordance with the New York City Fire and Building Code. So there would be no question about it.
Okay.
But I do not, in my professional opinion, believe that that would mean that the tenant himself or herself had to be removed from the loft space. We're talking about two different kinds of lofts here, so for clarity, the loft we're concerned about is the one that was constructed by the Stolman family above what we are calling the traditional loft space in the building. But in my professional opinion, I wouldn't think they would need to be removed from the traditional loft space, but there would have to be some sort of a reconciliation concerning the use of and or the addition of sprinkler heads below the added loft space.
Exactly. Okay. Thank you.
Right, and I would just add to that point that this is exactly why bringing these buildings into compliance is important so that issues like this can be addressed and dealt with as part of compliance. And there are some circumstances where there are mezzanines that don't have proper clearance, and that's why the board's narrative statement process is such an important part of the municipality code. I don't know if you had much chance to look at that portion of what we do. I know that's ongoing.
Well, certainly our position is just simply that we want the tenants to be safe. The FDNY has no desire to put people out on the street, remove them from their residential units, but we want to make sure that they understand. A lot of it is simply education. A lot of the average public, the average tenants don't understand some of the fire things that we as professionals are trained to see. And most probably that would be the case here. It would be a case where once it was explained to them the condition that they had created by it, at least, they would probably be in full agreement that a resolution needs to be adopted to make it safe. Thank you.
Well, I just would like to say I commend the board for putting on somebody from the FDNY, because that is a paramount safety issue.
Agreed. Thank you.
And the question I wanted to ask initially is, in this case, the oath judge entertained testimony about some other units,
Yes.
and based on the testimony that was offered, determined that they weren't covered, but we're basically treating that as dicta and not.
We're rejecting, the recommendation to the board is that we're rejecting the analysis.
Right. Rejecting the analysis, and therefore there's no prejudice toward someone from one of those units coming forward and making a coverage application at some other point in time.
Yes.
Okay. Fine. Thank you.
Thank you, Mr. May. We move forward. Is there a motion to accept this case? Mr. Delaney? Is there a second? Ms. Porter Rivera, thank you very much. Ms. Rivera? could you
Mr.
move
Barber?
forward?
Yes.
Mr. Barber?
Yes.
Mr. Roach?
Yes.
Chairperson Henson?
Yes.
Mr. Delaney?
Yes.
Ms. Golden Rivera?
Yes.
So,
Yes.
7 in favor, 1 absent.
Thank you, Ms. Rivera. The second case involves an applicant, Eric Conrad, applicants Eric Conrad and Aaron Elliott, 43-49 Bleecker Street. That's appropriate. Manhattan. Docket number TR 1255 and TR 1256. Ms. Cruz, please present.
On March 11, 2014, attendants of Unit 605 and 607 at 43-49 Baker Street filed applications seeking Article 7C coverage pursuant to MDL 2815. Prior to scheduling the trial date, OAT scheduled 2 settlement conferences. The first conference was on October 6, 2014, and the second conference was set for November 24, 2014. For the first conference, OAT served Mr. Conrad at his attorney's address, which is the address listed on the first page of his application. OAT served Ms. Elliott at the building, the address she listed on the first page of her application. Neither tenant appeared for the first conference. On October 3, 2014, Judge Globe granted Mr. Conrad's counsel's request to withdraw as counsel. OAT sent a second notice to tenants at their respective units. Tenants did not appear for the second conference. On January 30, 2015, OAT sent a notice of hearing. The notice advised the tenants that the date was marked final against them. It was also advised that if the tenants failed to appear, that their applications may be dismissed for failure to prosecute. OAT served tenants at the building's address. Tenants did not appear for the hearing date. Owner's attorney moved for dismissal of the applications with prejudice. In the report, Judge Globe recommended that the Loft Board dismiss the applications with prejudice for failure to prosecute. Here, the tenants failed to appear at oath on 3 different dates: October 6, 2014, November 24, 2014, for conferences, and on March 4, 2015, for a hearing. oath marked January 30th, 2015 notice for a hearing, final against them. Having granted the request to withdraw as counsel, oath properly served the tenants at the building's address, yet the tenants failed to appear. We note that more than 30 days have passed since the date of the hearing and tenants have not filed a written request for reinstatement. Mr. Conrad did not oppose his attorney's motion to withdraw, nor did he hire a new counsel to represent him in this case. It has been more than 2 years since the filing of the application, and there's been no communication from the tenants. The staff recommends that the board dismiss the applications with prejudice and for failure to prosecute.
Thank you, Mr. Cruz. Does anyone have any questions, comments about the case? Thank you. Is there a motion then to accept this case? Mr. Carver, thank you. Is there a second? Mr. Shelton, thank you.
Mr. Carver?
Yes.
Mr. Bradford?
Yes.
Mr. Boccia?
Yes.
Chairperson Vincent?
Yes.
Mr. Delaney?
Yes.
Ms. Golden Rivera?
Yes.
Ms. Shelton?
Yes.
7 in favor, 1 absent.
Thank you very much. So this brings us to the conclusion of our September 15th. I'm sorry, yes, sir.
Can I just ask one question?
Yes.
Are we planning to be meeting here on a regular basis?
Absolutely. So this is our new location.
This is our new home.
Yes, sir.
Okay. Do you think there's any way that we can kind of calm down the party in the hallway during meeting times?
Yes, sir. You have sent me quite a bit, as you can tell, at this meeting, so we will make sure that it's correct. Yes. Absolutely. Thank you. This concludes our September 15th, 2016 Loft Board meeting. Our next public meeting will be held here at 280 Broadway again on October 20th at 2 p.m. Board members, please remember to sign in and hand in your attendance sheets. Thank you so much.